if you or anybody dear to you has been waiting, sometimes for months, sometimes for years, for a green card or a visa development, then what I am about to present to you right now is something you absolutely must not overlook. Because this month, something truly significant has shifted in the U.S. immigration system, and it impacts hundreds of thousands of families throughout this country and across the globe. So remain right here because in the coming few minutes, I am going to guide you through the largest green card and visa processing developments for April 2026, clarify precisely what they signify for you, reveal who can take action right now, and provide you the exact measures you need to pursue today. This is US Updates Hub, and as always, we are here to ensure you possess the knowledge you require delivered clearly, truthfully, and without the anxiety and bewilderment that so frequently accompanies this subject. Let us start with what is arguably the single most thrilling development in this month's bulletin. And that is what has occurred in the F2A visa category. Now, if you are unfamiliar with the terminology, let me describe it simply. The F2A category encompasses the spouses and unmarried children below the age of 21 of lawful permanent residents. Put differently, green card holders. Not U.S. citizens, but green card holders. And for the families of green card holders, this category has traditionally been one of the most agonizing places to wait. There have been backlogs extending for years with families living apart, spouses separated, children growing up away from a parent, all because the system simply had more applicants than available visa numbers. But here is the development. As of the April 2026 Visa Bulletin released by the U.S. Department of State, the F2A category has returned to current across all countries on the dates for filing chart. Now, when we say a category is current, what that indicates in straightforward language is this. There is no wait. There is no priority date cutoff restraining you. Eligible spouses and children who are physically present in the United States can immediately submit their Form I-485, the application to register permanent residence or adjust status regardless of their priority date. That is a massive, truly life-altering development for thousands of families. And here's some additional background that makes this even more extraordinary. In September 2023, nearly 380,000 approved Form I-130 petitions in the F2A category were sitting in a line waiting for a visa number to become available. 2 years later, that number had fallen to 22,990, a 94% drop according to USCIS data. Let that register for a moment. A 94% reduction in the waiting list. That is not a minor enhancement. That is a dramatic clearing of the queue. And the reason it carries such weight right now is that it has enabled current status in this April bulletin. This has not occurred since 2022, and it may not persist. I want to be extremely straightforward with you here because this is crucial. Visa bulletin dates can shift backward, what immigration professionals call retrogression, and that can occur with very little advance notice. The F2A category was current briefly in late 2022, then retrogressed for over 3 years. Families who missed that opening are only now receiving another opportunity. So if you qualify, now is the moment to act. Not next month. Not after you contemplate it for a few weeks. Now, and I will explain exactly what measures to pursue shortly. But first, let us step back and comprehend the broader landscape of what the April 2026 Visa Bulletin signifies, because the positive developments extend well beyond just F2A. The Visa Bulletin, for those who are newer to this journey, is a monthly publication from the U.S. Department of State. It is the government's authoritative reference to immigrant visa availability. It informs green card applicants, both those within the United States who are adjusting their status and those overseas going through consular processing, when they can proceed forward. The bulletin functions as the government's definitive reference for immigrant visa availability, establishing the timeline for both family-sponsored and employment-based applicants. The bulletin operates on 2 charts. The final action dates chart reveals when a green card can actually be granted and delivered. The dates for filing chart reveals when you can turn in your documents in advance, even if your visa number has not yet been formally issued. For April 2026, USCIS has verified that both family-sponsored and employment-based applicants should reference the dates for filing chart. This is actually noteworthy in its own right because it means the more advantageous earlier dates apply, granting more applicants the ability to enter the system sooner. Now let us examine what occurred across the family-based categories more broadly. The F1 category, adult children of U.S. citizens, progressed meaningfully by approximately 6 months across most countries, while the F2B and F3 categories also demonstrated steady advancement. To frame that in perspective for F1 applicants, a 6-month progression in a single month is considerable forward movement. That means if your priority date was previously past the cutoff, it may now be within grasp. F2B, which encompasses unmarried sons and daughters aged 21 and older of green card holders, shifted from March 15, 2017 to August 8, 2017. F3, which encompasses married sons and daughters of U.S. citizens, shifted from July 22, 2012 to November 22, 2012. And F4, which encompasses siblings of U.S. citizens, shifted from March 1, 2009 to May 15, 2009. These categories still carry lengthy waits, and I want to recognize that, honestly, but movement, even measured movement, means individuals are getting closer. It means the system is not stalled. On the employment-based side, the landscape is more complex. EB1 and EB2 remained largely static, though EB2 India progressed slightly. EB3 demonstrated meaningful forward advancement for India and returned to current for most other nations. For skilled workers in the EB3 category outside of the heavily backlogged nations like India and China, the dates for filing being current is an open pathway. If you are a professional with an approved I-140 petition in EB3 and you have been waiting to submit your I-485, this month may be the opportunity you have been searching for. And even for Indian and Chinese nationals in EB2 and EB3, any forward advancement is truly welcomed news after years of extraordinarily sluggish progress. Now, there is background behind why these dates have progressed forward so substantially, and I want to present it to you because comprehending it assists you think about what might unfold next. Since October 2025, USCIS has continued to use filing dates to determine when applicants can submit Form I-485. The immigrant visa freeze affecting 75 countries could be connected to the dramatic forward surge in the March and April 2026 Visa Bulletins. In other words, when nationals from a significant number of nations are unable to proceed forward with consular processing, the visa numbers that would have been allocated to them become available for others. If nationals from nearly a third of the globe cannot proceed forward with consular processing, a surplus of immigrant visas may exist. And because USCIS must forecast supply and demand into the future, a sustained freeze indicates that the overall number of green cards available remains manageable. This is a double-edged circumstance. It means positive developments for those who can act right now, but it also means the forward advancement may not persist indefinitely. The State Department warns that forward advancement in 1 month does not guarantee continued progress later in the fiscal year, and retrogression remains possible later in the year if demand surpasses available visa numbers. So please treat this seriously. The opening is real, but openings can shut. Let me now guide you through the practical measures you need to pursue if you believe this month's bulletin could pertain to you. I want to maintain this accessible and straightforward, so let us approach it piece by piece. The very first thing you need to accomplish is identify your visa category. Are you the spouse or minor child of a green card holder? That would position you in the F2A category. Are you an adult unmarried child of a green card holder? That is F2B. Are you a married child of a U.S. citizen? That is F3. Are you a sibling of a U.S. citizen? That is F4. Are you an employment-based applicant, a highly skilled worker, an advanced degree holder, or someone in a specialized field? You would belong to the EB1, EB2, or EB3 categories. Knowing your category is the bedrock of everything else. Once you identify your category, locate your priority date. Your priority date is typically the date when your immigrant visa petition, your Form I-130 for family-based categories, or your Form I-140 for employment-based categories was originally submitted. You will discover this date on the receipt notice USCIS dispatched when your petition was submitted. If you are uncertain, review your documents or reach out to whoever assisted you in filing. Next, visit the official Visa Bulletin on the U.S. Department of State's website at travel.state.gov. Find your category and your country of birth in the April 2026 Visa Bulletin. Compare your priority date to the date displayed. If your priority date is earlier than the date in the chart, or if the chart indicates current, you may be eligible to submit. But here's a vital step that many individuals overlook. Before you submit anything, verify with USCIS that the dates for filing chart is authorized for your category in April. USCIS must independently authorize use of the dates for filing chart each month. That authorization is not automatic and must be verified before any submission is made. You can confirm this at uscis.gov Visa Bulletin information. This page is refreshed each month, and it will verify which chart USCIS is accepting applications under. Do not bypass this step. If you are in the F2A category and qualify to submit, here is what a complete adjustment of status package typically encompasses. You will require Form I-485, the application to register permanent residence or adjust status. You will require Form I-864, an affidavit of support from your sponsoring family member, establishing they meet the income requirements. You will require supporting documents, including proof of the sponsor's permanent resident status, proof of your relationship, whether that is a marriage certificate or a birth certificate, passport copies, and evidence that you have maintained lawful status in the United States. You will also want to strongly contemplate filing Form I-765, the application for employment authorization, and Form I-131, the application for travel documents, at the same time. Filing Form I-485 early can prevent future complications around expiring underlying status. And filing simultaneously allows you to request advance parole or an employment authorization document, which permits you to work or travel internationally while your green card petition remains pending. These simultaneous filings can be a considerable breakthrough for many families. I also want to speak briefly to those of you who are in employment-based categories and have been monitoring the EB3 advancement this month. If your priority date is now within range, and especially if it has turned current on the dates for filing chart, this is an ideal time to have a discussion with an immigration lawyer about submitting your I-485 if you have not already. And for those with pending I-140 petitions who are evaluating premium processing, I do want to present an important development on that front as well. As of March 1, 2026, USCIS implemented revised premium processing fees. The premium processing fee for Form I-129 non-immigrant worker petitions requesting classifications such as E3, H-1B, L-1, O-1, and TN increased to $2,805. The premium processing fee for Form I-140 immigrant petitions for employment-based categories also increased to $2,805. Additionally, the premium processing fee for certain Form I-539 and Form I-765 applications also increased to $2,955 and $1,090 respectively. These increases are part of a biennial inflation-based adjustment authorized under federal law. The objective is to preserve the real value of premium processing services and maintain USCIS operational capacity. Now, I recognize that higher fees are never pleasant news, but here's the important perspective. Premium processing remains accessible for many key categories, and it can still be a vital instrument for time-sensitive circumstances. Most employment-based petitions are guaranteed a response, either an adjudication or a request for additional evidence within 15 business days when premium processing is requested. If you are encountering a gap in work authorization, a cap-gap predicament, or a business-critical deadline, premium processing may still be worth the expenditure. Just ensure any Form I-907, the request for premium processing service, is postmarked with the revised fee because requests submitted with outdated fees after March 1st will be rejected and returned, resulting in setbacks. Now, I want to take a moment to be forthright with you about something, because that is what this channel represents. The broader landscape of USCIS processing times remains demanding in 2026. The duration it takes USCIS to process most petitions remains sluggish, with some cases requiring several months or even years to reach a determination. Family and employment petitions face extended waits, with I-130s for green card holders requiring up to 35 months, and perm labor certifications adding over 16 months to green card timelines. This is genuine and it is exasperating, and I do not want to downplay it. The positive developments in the Visa Bulletin this month do not erase the underlying backlog difficulties. What they do is unlock specific filing openings that could safeguard your place in line, obtain you work authorization sooner, and position you for a green card approval when your final action date becomes current. So please leverage this moment strategically. Consider it this way. Filing your I-485 now when the dates for filing chart permits, it is like reserving your place in a line even before the window opens. You are safeguarding yourself. You are securing your position. With cutoff dates shifting so quickly, securing your place in the adjudication line could create a meaningful difference in how rapidly your timeline to a green card progresses forward. I also want to briefly address those of you who may be outside the United States going through consular processing. The Visa Bulletin developments are pertinent to you as well, particularly if your priority date has turned current on the final action dates chart. Your pathway is through the National Visa Center, and ultimately a consular interview at a U.S. embassy or consulate in your nation. Monitor your NVC case status. Confirm your documents are complete and refreshed, and follow any directives from the embassy attentively. If you have a pending appointment or are awaiting one, remain in close communication with your lawyer or accredited representative. Here's something else I want to urge all of you to accomplish regardless of where you stand in the journey. Keep your documents organized and up to date. This means knowing where your priority date receipt notices are. It means confirming your passport will not expire in the middle of your case. It means ensuring your financial sponsor has current income documentation prepared. It means reporting any address changes with USCIS immediately through your USCIS online account or by submitting an AR-11 form. These minor administrative measures are the things that prevent cases from getting stalled for avoidable reasons. And if you have a child approaching the age of 21 who is included in your petition, please consult with a qualified immigration lawyer as soon as possible. There are legal safeguards under the Child Status Protection Act that may help preserve eligibility, but timing is everything, and professional guidance is indispensable. Before I conclude, I want to present a brief but significant reminder that this content is for informational purposes only. It does not constitute legal advice, and every immigration circumstance is distinct. The developments I have presented today are drawn from the official April 2026 Visa Bulletin from the U.S. Department of State, guidance from U.S. Citizenship and Immigration Services, and reporting from credible sources. But immigration policy can shift at any time without warning, and what holds true today may change by next month. Please confirm all information through official sources: USCIS at uscis.gov, the Department of State's Visa Bulletin at travel.state.gov, and the Department of Homeland Security at dhh.gov. And for anything specific to your individual circumstance, please seek out a qualified immigration lawyer or accredited representative who can examine the details of your case. On-screen note: policy changes can occur at any time. Information in this video is current as of April 11th, 2026. Always verify with official sources before filing. This is why US Updates Hub exists, to be the source you can rely on to navigate through the complexity, deliver you the developments that matter, and assist you comprehend what they signify for your life. Whether you are a new arrival navigating this system for the first time, a senior who has been here for decades and is finally pursuing citizenship or residency, or a working professional waiting for that employment-based green card to progress forward, you deserve straightforward, truthful information, and that is precisely what we are dedicated to providing you. If this video assisted you today, please take a second to give it a like and forward it to someone in your community who could benefit from learning about these April 2026 developments. Your shares create an enormous impact in helping families who require this information actually discover it. Subscribe to US Updates Hub so you never miss a monthly Visa Bulletin analysis, a USCIS policy development, or a change that could influence your immigration journey. Review the description beneath this video for links to official resources, including the April 2026 Visa Bulletin, USCIS processing time information, and guidance on where to locate qualified legal assistance. You have labored hard to reach where you are. You have been patient, and for many of you, this April 2026 bulletin is the moment you have been anticipating. Do not allow it pass you by. Take action. Confirm your eligibility through official sources. Seek a professional if you have any uncertainty, and keep pressing forward. We are supporting you every step of the way. This has been US Updates Hub. I will see you in the next one. This content is for educational and informational purposes only. It does not constitute legal advice.